The longest-serving consort in British history died peacefully at Windsor Castle back in April at the age of 99. In July, the High Court ruled at a secret hearing the media were to be barred from attending the hearing of the will. Now, The Guardian has launched legal action against the Attorney General and the Queen's private lawyers. They argued the High Court should have properly considered whether the press should be allowed to attend the hearing and present their arguments. Their lawyers said the failure to do this was a contradiction to the principle of open justice and demanded the case be reheard. Open justice means proceedings ought to be open to the public, including contents of court files and public viewings of trials. For more than a century, it has been convention for when a senior member of the royal family dies, an application to seal their will is made to the President of the Family Division of the High Court. This means the wills of senior members of the firm are not open to public inspection in the way a will would ordinarily be. Sir Andrew McFarlane, the current president, heard legal arguments from both Philip's estate and the Attorney General. He ordered Philip's will is to remain sealed for 90 years from the grant of probate, which is the formal process which confirms the authority of an executor to administer his estate. This may only be opened in private even after that date. He said, "I have held that, because of the constitutional position of the sovereign, it is appropriate to have a special practice in relation to royal wills. There is a need to enhance the protection afforded to truly private aspects of the lives of this limited group of individuals in order to maintain the dignity of the sovereign and close members of her family." He said the ruling was to make as much detail as possible public without compromising the conventional privacy afforded to communications from the sovereign. Sir Andrew argued his decision to hold the hearing in private was a series of announcements would have generated very significant publicity and conjecture. He concluded this would be entirely contrary to the need to preserve the dignity of the sovereign and protect the privacy surrounding genuinely private matters. Sir Andrew said the publicity would, therefore, in part, defeat the core purpose of the application. "I accepted the submission that whilst there may be public curiosity as to the private arrangements that a member of the royal family may choose to make in their will, there is no true public interest in the public knowing this wholly private information. The media interest in this respect is, the degree of publicity that publication would be likely to attract would be very extensive and wholly contrary to the aim of maintaining the dignity of the sovereign." The judge said the Attorney General was at the hearing to represent the public interest and there was no legal reason for any further representations by media organizations. Due to the coronavirus pandemic, only 30 people were able to attend Philip's funeral. In a very powerful image, the Queen was pictured sitting alone as her husband's coffin entered into St. George Chapel, at Windsor Castle. The Duke of Edinburgh was interred in the Royal Vault of St. George Chapel at Windsor Castle.